been convinced beyond a reasonable doubt, as I kept thinking about whether there was or whether there wasn't, that that really is my decision regarding this, because I can't figure out exactly what happened, given that the court has found and will find that the defendant is not guilty.
Thank you, Your Honor.
Thank you, Your Honor.
Hey everyone, my name is Davros. Just watching some court.
State of Michigan versus Raven Nobles, case number 24S00295.
Tiffany Woods for the people.
Matthew Mansour on behalf of Miss Raven Nobles, Your Honor. I have not had communication with Miss Nobles. Called and left a voicemail, but no communication.
All right, the last time she was supposed to be here, and she, I believe she wasn't. She was hospitalized that day and didn't show up, and we were supposed to have proofs today of her hospitalization. Is that correct?
I think, Your Honor, the last time she was here, the time before that, she was not. And then we asked her last time to provide the records, like you said.
Okay. What is your request, Ms. Woods, in this particular matter?
Judge, I'd ask for a bench warrant.
Bench warrant to issue. This is an aggravated assault and a malicious destruction of property. I'm going to set the bench warrant at 5,000, 10%. State of Michigan versus Jonathan McKinney, case number 21 FB 1790.
Tiffany Woods for the people.
Assistant Public Defender Davi Lebo for Mr. McKinney. I have not had contact with Mr. McKinney, unfortunately. I did leave him a message.
Is he out of custody? Did you check to see if he's in? I thought at one point in time.
I'll check VineLink, Your Honor.
Getting this wrong. Is this the guy? No, this is not him. Well, he was in custody in Wayne at one point, but I guess he got out, and he had no job in October. Then he set up a payment plan in December.
I do not.
Okay, go ahead. I'm sorry. Don't see him?
I don't see him in custody on VineLink, Your Honor.
Have something?
No,
Defendant has failed to appear and failed to show $10,000, 10%.
Thank you.
Didn't show last time either. The record should reflect that. Well, we'll call the matters of Sherry Vinston, 21 FB 1648, 21 FB 1837, 24 S 4479378 and B, as well as 24 W 001293A.
Tiffany Woods for the people.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Sherry Vinston. Your Honor, it didn't look like any payments had been made, and unfortunately her number is not in service, so I've had no contact.
Here in May, when she set up the payment plan, she actually pled in May. But at least on one case, she has not made any payments. And today, we're here for show causes in these matters. What I'm going to do is give her one more chance to show. I'm going to schedule it for a contempt hearing in all of these cases, actually. I'm going to put it out sometime for 60 days to September 9th,
Hey, how's it going? Sorry.
2025
My first
at
time.
10 a.m.
Just watching Judge Washington right now.
If she doesn't show, I'm issuing
regular
bench warrants.
docket.
If she
I
does
just
show
jumped
and
in
she hasn't
about
made
maybe
any
like 2
payments,
minutes ago, so
I still might be issuing bench warrants, so we'll see.
yeah, so they haven't really done anything yet. They just got back. Just a bench warrant. That's the only one that I've seen so far. You know. It's my first time, so I'm adjusting the volume and trying to figure everything out. So, I hope you're having a good day, though, whoever you are. Hopefully, we have a good time in Judge Washington's court. Let's see if something exciting happens. Let's see kind of how people behave. All right. Thanks for being here, by the way. I appreciate it. Thanks for spending time with me.
Wait a second. State of Michigan versus Kevin Williams, case number 21S00314.
Tiffany Woods for the people.
Matthew Mansour on behalf of Mr. Kevin Williams. And no recent payments have been made according to JIS.
He was just sentenced on April 8th and set up a payment plan at that time. $75 per month. What is his outstanding balance?
$475.
Okay.
Yep.
I'm going to he was here at the last hearing, so I'm gonna schedule it for a contempt hearing. And I'll put that
Deborah.
over to September 9th.
We're just watching Judge Washington right now. Just a regular docket. I just jumped in, so there was a bench warrant for
At 10 o'clock
failure
a.m.
to appear. That's it so far, really. I hope you're having a good day, and thanks for being here. I'm finding a new court. All right. So I found Judge Stevens.
Okay. Then the Texas Code of Criminal Procedure is this thick portion right here, and that is the code of laws that describe how a case procedurally works its way criminally from the very
All right.
beginning at investigation all the way through into appeals. Then we have the rules of evidence. The rules of evidence are what we use primarily in trials, and that dictate the proper procedure and method where evidence is presented and how it is ruled upon when objections are made. You just can't say, here's a pen, I want it admitted, and that's not going to get it done. All items of evidence to be admitted have to be, whether it's testimony or objects, for example, like a pen, have to be relevant and reliable. And the court judges are what we call the gatekeepers of the admissibility of evidence. I'm very sensitive evidence since I was on the Rules of Evidence Committee that wrote the rules. I've written a lot of articles on law, and the presumption of innocence article is the lead article used in the state that I wrote, and then Beyond a Reasonable Doubt article, but the Rules of Evidence, they were very special since I was on that committee. And when evidence is presented, if an attorney objects, I must rule on it like a basketball official on calling a foul. If I overrule the objection, then the question that was asked that is being objected to will be answered. If I sustain the objection, then it won't be answered. But it could be asked in a different way that meets with the rules of evidence based according to the court's ruling. From time to time, the court will give you an instructions of law. At the end of this trial, I will certainly give you a compilation of jury instructions for your deliberations. Each of you, though, gets to determine what the facts are, not me. That's your job. You get to determine how much weight and credibility is to be given to the evidence, including the testimony of witnesses. In considering the weight and the value of the testimony of witnesses, you may consider a witness's appearance, attitude, behavior, their interest in the outcome of the case, any relationship they may have with the parties, the inclination of the witness to tell the truth, the probability or improbability of the witness's statements. And as we talked about in voir dire, you can draw reasonable inferences from the statements of witnesses. You remember logic rules that we learned about in school? If something A equals something B. And if something B, that something B equals something C, thus A must equal C. You will use the kinds of attributes and practices that you use in dealing with people every day when you're listening to the testimony of witnesses. And that's what you do. You're not thinking of it just exactly like the way I'm saying, but we all think the same way. We listen, and then we are making decisions how much of this to believe. All of it, some of it, none of it. We are drawing on our life's experiences, our education, common sense. And that's what is so important. Don't forget to bring that along into your determinations of the evidence, common sense. And there is no case where you get 100% of all the information. You just don't ever get it. You have to fill in gaps using inferences, common sense. But you do that every day. So don't forget to bring that along. And you can use all other factors you feel might help you in giving the testimony of the witnesses the degree of credibility you feel it should deserve. Now, the trial is going to proceed in the following way. In just a moment, I'm going to ask the state of Texas to present the indictment. The defendant shall plead to the indictment. And then each party gets to make opening statements, which are brief overviews of what they feel their evidence will be presented to you. And because the state of Texas has the burden of proof going forward, and that's because of the presumption of innocence. All persons charged with crimes are presumed innocent, unless, we all know that one, unless proven guilty. So that presumption of innocence means it's not on the obligation of defendants to prove their innocence. It's on the obligation is on the accusing authority, the state, to go first, present evidence, and after they call witnesses and question witnesses, the defense gets a fair opportunity to cross-examine those witnesses. At some point in time, you will hear the state say, "We rest." When that happens, the defense may or may not present evidence. Sometimes they don't. And when that happens, it's not like the sky is falling. I know, and you know, what is going to happen by using common sense. The defense will be arguing, the state didn't meet its burden to prove its case beyond a reasonable doubt. Remember, that's what it takes. It's not preponderance of the evidence like in the state courts across